Broadcast is now starting. All attendees are in listen-only mode.
Hey, good afternoon, everybody. My name is Cy Alba. I'm a partner at a government contracts group, and I'm here with the head of our corporate group, Jonathan Bush.
Hello, everyone.
And we're going to get started talking about mergers and acquisitions. It's an overview of M&A processes and considerations for government contractors. As you might know, PilieroMazza is a government contracts law firm that also serves a lot of the needs for small and mid-sized companies and certain large companies, mainly working in the federal space, but with labor and employment, litigation, and general corporate like M&A issues. And so I'll have Jonathan kick things off, and then we will move forward through the M&A portion.
So today we're going to go through the general stages of an M&A deal at a kind of high level and talk about deal structuring, some considerations of asset versus stock transactions, a little bit about due diligence issues, and then a fair amount of special government contracting considerations when you're involved in an M&A deal. So, like I said, we're going to give a bit of an overview of an M&A transaction, both structuring the deal and performing due diligence, and importantly, from a seller's perspective, preparing for a due diligence process, and then identify the unique regulatory issues that are involved in transactions when there's a government contractors, including small business size issues, affiliation, recertification, and novation. So onto the initial transaction steps. And by the way, we didn't say, if you have questions as we're going through any of this, feel free to submit it through the web form. And if it's pertinent to the topic we're talking about at that second, we may interrupt the presentation and address the question, or we may save them for the end of the presentation. So when you're initially thinking about an M&A deal from either a seller or buyer perspective, but especially from a seller perspective, you want to make sure that you have attorneys on your team that specialize in both in M&A, but also have a good awareness of the unique considerations that are necessary when you're dealing with M&A and you're either a seller or buyer that's a government contractor. You're also going to want to assemble, depending on the size of the deal, but I find that they're almost always helpful, is the right either financial advisor, investment banker, or broker. They can help you with valuations. If you're looking to acquire a company, they will help you beat the bushes for appropriate acquisition targets that are harmonious with your existing business. If you're a seller, they can be very helpful both in the way you package your information to help you develop and present your story. And then if you decide to proceed with a transaction, they will assist you with marketing you to as wide an audience, as you're comfortable with.
Yeah, and one other thing to add, I know in certain spaces when you're talking about financial advisors, if it's a relatively large sale, or if, let's say, you're planning on retirement and things like that, where to put the money after a sale, or a lot of financial advisors have some expertise in charitable giving if you're planning on going that route. And so just things to keep in mind at the beginning. If you have a financial advisor before you do the deal, especially on the seller side, you can look at and determine how things should be structured to maximize your post-sale plans. Again, whether it be retirement or charitable giving, some of those things could implicate how you put the deal together to begin with.
And then moving on to from the buyer's perspective, some companies that are looking at acquisitions may not realize the number of avenues they have to finance an acquisition. So dialoguing with your commercial bankers, if you have one, or seeking out new commercial bankers to provide you ideas on that front can be invaluable, because we've certainly seen transactions where fairly small in comparison to the size of the target company that was acquired, companies were able to finance a lot more of the purchase price than they might have originally thought when they were thinking about getting involved in an acquisition process. Accountants are always critical for structuring the deal, both from a tax and accounting perspective, but especially a tax perspective. And then, depending on the nature of the companies involved, you may want to involve other specialists. If there's, a seller that has a lot of real estate or, facilities, environmental consultants can be very helpful and critical to assessing liability issues. Insurance specialists, if the target has a complicated web of potential liabilities or just has a complicated insurance program and you're thinking about buying the entirety of the target, they can be helpful as well. When you're getting ready to sell, it's really important, even before you don't really need any specialists to help you with this process, but it's really important. Most sellers have not experienced, or many sellers have not experienced, the level of due diligence that a buyer will request of them as they go through negotiation of an M&A transaction. And to the extent that you can front load and take care of some of these matters, it will not only facilitate due diligence, but it may, either bolster the purchase price you're seeking or, strengthen your negotiating position with respect to purchase price, because there's nothing that makes buyers nervous, especially when they're buying the entirety of an organization, i.e. all the equity, like poorly organized corporate records. So everything from everyone's favorite documents that small companies often let fall by the wayside after initial organization. You're following your bylaws, your stock ledgers, your corporate minutes. You may have to go and adopt resolutions affirming decisions that were kind of taken orally in the past and other things to just document how you got to the present day. But it's very important from a buyer's perspective. Along the same lines, making sure all your registrations, licenses, permits are up to date so that when, for example, a buyer does a search of all the jurisdictions in which the seller does business, they're not going to get back information from the states that the organization's not in good standing and the like. You're organizing your financial reports, your tax records is probably the most critical thing, because obviously a buyer is going to crawl all through a seller's financial statements, and if they're not in order, then that's a big warning sign that may put a buyer off on following through with the transaction. Making sure any bank financing papers you have are in order and up to date, your commercial contracts, all issues related to employee matters, your handbooks, any employment contracts you have, independent contractor contracts, employee benefit plans. Make sure all of that's organized and up to date. The same with your insurance, and if you have key intellectual property, make sure that all of your records and trademark maintenance and other related intellectual property issues are under control, and that will make the due diligence process that we talk about in a little bit that much easier.
Yeah, and I'll mention one thing as well with regard to the corporate records. I've seen these things come up, and it's a good thing just to have and maintain going forward, because I had an issue come up recently where it was in regard to size protest. In fact, not even a sale, but it would have been bad in a sale too, is when you start looking at the corporate records, the documents have never been updated, and in addition to that, they were inconsistent with the tax filings. And so you have a situation where the tax filings are showing K-1s going to one person, but the corporate documents, they were never changed. And so it looks like the owners of the company from the corporate records perspective were different from the people who were paying taxes. And that could be a problem from an IRS perspective and just from a corporate perspective, from a liability perspective. And when you give reps and warranties saying, I and my partner who signed this are authorized to take XYZ action, but that transfer never occurred. And so therefore you're pretending basically that the owners of the company are 2 people or 3 people or whoever, and really that was never appropriately changed. And so you're paying the IRS taxes and you're doing other things, but you actually don't have the equity because you never properly transferred it. That can be a problem. And then if you've gotten to the doorstep of a deal, especially some companies that get to be 30 or 40 million don't keep accurate records, and they're not changing these things because it's just closely held, so they don't think about it. Then they get to the set of a deal or a size protest or whatever, and all the documents are wrong. And then it's a scramble to see, well, how can I even get this person to sign the appropriate documents I need to have them transfer their ownership, because we never did it right the first time around, or the person's dead. So just keep track.
So now we get into, and by the way, I did see there's one question about asking us if we can walk through the contract waiver process, a request process, and timing in conjunction with an acquisition or merger of government contractors. We will be addressing those issues a little later on in the presentation, so didn't want you to think we were ignoring you. In a kind of broad overview of the stages of an M&A transaction is what we want to talk about next. So prior to a deal, when you're thinking about launching a process, if you're a seller, your attorneys can help you put a NDA together that's appropriate for an M&A sales process that protects your confidential information and your interests in connection with the deal. When you get a little further along and you're actually in talks with a specific buyer, it may make sense to memorialize the broad terms of a transaction with a letter of intent. You do have to be careful in doing that to make clear that and we'll talk about this a little more, make clear that the letter of intent is really not binding, and that'll protect you in dealing with the SBA as well, who, if you did have a binding letter of intent, they could give present effect to it, and you would, if you hadn't filed notifications, you would you'd already be behind the 8 ball, but we'll talk about that in a little while. The deal structure, whether to do an asset acquisition or sale or a stock purchase or a merger, we'll talk about those issues and related affiliation issues for government contractors. Talk a bit about due diligence, a bit about the principal transaction documents in an M&A deal, and then what typically follows the closing of an M&A deal as it relates to a government contractor. So in structuring the deal, you'll often hear, if you're a seller, a buyer may approach you and talk to you about acquiring your assets. The reason buyers, if all other things being equal, prefer asset acquisitions are twofold. The main reason is when a buyer buys the assets from a seller, they get a stepped up basis in those assets and can allocate the purchase price amongst those assets, and assets that can be depreciated quickly. The buyer gets an immediate advantage from a tax perspective in the depreciation of those new higher valued assets. The other reason is when you buy assets rather than equity, the only liabilities you assume, absent some exceptions that are involved with certain legal regimes like the environmental law regime, you don't assume any liabilities along with those assets other than what you specifically set forth in the contract. So there's much less chance of a surprise liability hitting you as the buyer following closing. Now, some of the downsides of an asset acquisition is that title transfer of those assets, you have to deal with each asset and how you transfer title. It may be a simple bill of sale. However, if you're talking about contracts, for example, you have to assign them. And potentially the counterparty to that contract has the right to say no to assignments. So it can make getting the business the buyer wants more complicated to do it as an asset transaction. If you're talking about government contracts, you have to go through the novation process to get the government to agree that the seller can assign it to the buyer. And there's other issues that make that not the simplest of exercises. In an asset purchase, a seller entity continues to exist after the transaction. Sometimes when you're dealing with government contracts, the seller will, since it's continuing to exist and until a novation has taken place, which is often a post-closing covenant, the seller will subcontract the work on the contract for which novation is being sought to the buyer. And then often, if the novation cannot be obtained, there may be an unwind provision in the contract, which basically brings everybody back to step one before the transaction took place.
And just there was a question about novation, about whether or not you have to talk to every contracting officer or just a single government ACO. It's either the way it's supposed to work is that you present the novation documentation to either the ACO, the administrative contracting officer, who's in charge of all the contracts, if the contractor has one, or it's to the contracting officer responsible for the largest outstanding balance of work remaining on contracts that has been funded. And so when you're talking about either one, you just are supposed to provide the novation paperwork to the one individual, and they are supposed to shepherd it through the various other agencies. Sometimes if you want to speed up the process, you can send it to that one person who's responsible, but then speak to the other contracting officers and have them aware and reach out to the ACO or the CO with the largest outstanding balance to make sure that it's being facilitated. But technically, the one individual is supposed to shepherd it through. And also, there's a question about novation. Do you have to novate all the contracts to the firm being acquired? So depends on the asset. So any asset that you're buying, so if you're buying a bunch of assets related to, say, a division, let's say in that division there are 2 contracts, then only the 2 contracts have to be novated. It's whatever you're buying. If you're buying the entire company through a stock sale, which we'll get into in a minute, you don't have to novate unless you do a merger, and that triggers novation of all the contracts that entity has.
So that's a segue. The next slide, we're talking about structuring an equity transaction, an equity purchase. Sellers generally prefer equity sales because, especially if they're selling almost all of the assets of their business, it's much easier from a seller perspective to just sell the equity. That way, the entity is off their hands, so to speak, and the buyer has, by operation of owning the stock, assumed all the liabilities associated with that entity, and the seller can kind of move on into the future, kind of free of worry about that, aside from whatever liability provisions are in the contract, which we'll talk about in a second. So as I said, when you buy the equity through either a stock purchase or a merger, buyers are getting all known liabilities, but they're also getting unknown liabilities. And that's why, especially to sellers that haven't been through an M&A process before, they can be a bit overwhelmed and, depending on their personality, perturbed or peeved by the extent of a thorough buyer's due diligence request. Because if a buyer is buying the equity, they're getting potentially all kinds of liabilities that they don't know about, and you as a seller, you're an honest broker, but the buyer doesn't know that, and so that's kind of what the whole due diligence exercise, or one of the reasons for the whole due diligence exercise in the first place. So this bullet is here about a higher level of due diligence. As Sai said, there's no novation required generally if you're doing a stock purchase. You get all the assets. Now, is there a change of name or anything that they have to do after they buy the stock?
Yeah, so if you buy stock and you're just holding the company as a subsidiary, then you don't have to worry about anything. There's no novation, there's no change of name, there's nothing. You might have if the clause is in your contract, change of ownership notification that has to be made, but that's generally speaking as simple as just sending an email saying I'm the new owner. It has no impact on recertification for size or requiring any sort of novation or change of name. Like we said, it's merely notifying you that there's a new owner. I have had the government come back and insist on a novation package before, and we've done it just to avoid any sort of consternation. But frankly, that makes absolutely no sense, because as part of the novation package, you're supposed to have balance sheets before and after the transaction, both for the buyer and the seller, the new entity. If you've changed ownership, nothing is changing like that. There is no before and after. There is no new entity. It's simply the change of ownership. That's it. And with regard to the novation, also there was a question about IDIQ vehicles. If you're selling or buying assets that could include an IDIQ vehicle, you only have to do the novation for whoever the CO is in charge of the vehicle, no matter how many orders you have under it. They all are going to transfer to whoever the buyer is, because task orders without a vehicle doesn't really exist. They're sort of orphans, if you will, and they have to transfer with the overall IDIQ vehicle. We've had a couple people try to ask about transferring task orders without the vehicle to someone else who has a vehicle. There's strange issues with that. I think there might be arguments you could try to make that happen. In fact, I think in the process of might be trying to negotiate that. It's very odd though, and I don't think it's ever been successful that I know of to date. And if you sell the minority interest in a company, it doesn't trigger necessarily the change of ownership. You have to look at the clause that's in the contract. It might trigger other issues under small business rules we can get into in a minute.
So then when you do a stock purchase, you may, if you're dealing with small business administration size standards, you probably have to recertify as to your size status after you complete the acquisition. Then in terms of affiliation issues, we obviously, I don't know if you want to handle this one, Si, or.
Yeah, so when you're dealing with an affiliation, the small business status is important, right? Because you could potentially lose your contracts, or at least the agency loses the ability to take credit for them. So if you're selling your company to a large business or someone who's potentially large, and you trigger recertification, then what's going to happen is, at the very least, the agency can no longer take small business credit going forward. So if you want to think about structuring the transaction potentially to avoid recertification, and SBA has written the rules rather broadly to try to capture any and all circumstance. So from the buyer or the seller perspective, whether you're doing an asset deal that would require novation, or whether you're doing a stock sale, the way the SBA rules are structured is they're trying to capture recertification in both respects. With regard to an asset sale, you recertify on the contracts you've acquired, but arguably you don't have to recertify on your legacy work that you might already have. So if you're a small business and you have a bunch of work and you're buying assets, and those assets include contracts, you would have to recertify on the contracts at the time of the novation, but you would not have to recertify on the current legacy work that you have. However, if you're a small business and you buy another small business, the way the rule is structured is that if the buyer is a business and the seller is a business, and they both had small business contracts, you have to recertify on all the contracts that are in the business you're acquiring and your legacy contracts. So that's why a lot of small businesses are very careful about how they structure their deals, because if you buy a business the entirety through a stock sale or ownership sale, then you have to recertify on all your legacy work. And if you have grown to be a large business, that can be very problematic, because then even though you didn't sell to someone, you just bought another company and you have to recertify in all your current work, you could then make it so the government can no longer take small business credit for any of your legacy work, even though you grew organically. There are ways to get around that. We don't try to get into in the webinars or publicly necessarily, because you have to structure it very carefully. And there's legal arguments as to why it works that aren't 100%. There's some risk involved, but we have arguments and ways to structure deals, even if you're going to acquire another company or you want to acquire an entire company, to avoid having to recertify on your legacy work, which is usually something people are really trying to do. And so if you wanted to do that transaction, we could certainly talk about it under privilege and walk through some of the issues to avoid doing that. So the other thing here is you want to be careful with affiliation. So if you acquire another company, or if you acquire majority interest in that company, or even if you acquire a minority interest in the company, or if someone acquires a minority interest in you, you need to be careful what other terms and conditions you have in the operating agreement or the bylaws or whatever you might have, depending on your company, to make it so that they don't have negative control over you. Oftentimes, if you want to sell to a private equity fund, and a lot of times they want to take complete control, but if they're willing to take a 49% ownership interest, and I just did a deal like this where the private equity fund bought 49%, and we talked them through all the restrictions. It was a former 8A company, all the restrictions that they would have to go through and make sure that the private equity fund understood that they can't have the same kind of control or even veto rights. They're very restricted in what they can do. Otherwise, they're going to be affiliated, even with a 49% ownership interest. So there's other things that you can do, again, to walk through the specifics of the deal to make sure that you don't trigger affiliation due to negative control, not just positive control. Also, if you're looking to buy from the buyer's side, looking at who else that company might be affiliated with that you're buying, to make sure that they're not telling you, yeah, I don't have any affiliates, and they're talking about it in sort of the common nomenclature of what people think of as affiliates, not affiliates under the SBA rules. Because then when you dig deeper, you might find out, well, I don't have any affiliated company. Oh, yeah, but my brother has a company, my mother has a company, my father has a company, but we're not affiliated with them. Well, the rule is you're presumed affiliated with all of those people, unless you can find some sort of clear fracture. And so you, as part of your due diligence, you're going to want to look into those issues and make sure that there's no affiliation before you buy them, because that could be problematic.
Getting back into and as we get through the presentation and questions, if we miss one of your questions or if we just didn't address it because of timing considerations or the topic we were talking about, we will get back to you after the presentation, just so you know. In terms of documents for the deal, the letter of intent, I mentioned before how critical it is. Your letter of intent could set forth very specific things like purchase price, transaction structure, compensation arrangements for key people. It could set those terms forth, but the key thing for your letter of intent is that both sides have to agree in the letter of intent that none of those terms are actually binding. They're all subject to due diligence and negotiation of definitive transaction agreements to affect those. And you want to do that in any event, even if you weren't a government contractor. But if you are subject to SBA, the SBA regime, because you're a different one type of small business or another, that's especially true because of the SBA's present effect rule. Whereas if you don't make it crystal clear to the SBA in your letter of intent that it's not binding, they will treat it as binding and give present effect to the transaction that you outline in it.
Yeah, and even if you say it's completely non-binding, SBA can still give it present effect if they think it's sufficiently definite to show that there was some meeting of the minds. A lot of times the price term is something that SBA puts a lot of weight on. So if you have an LOI that's subject to diligence and you have a specific price in there, which is often something people want, especially the seller, right? That is a big sort of red flag for SBA that there might be a meeting of the minds. You might have already come to some sort of agreement, even if it's not binding. And so the ways you can get around that is when you're structuring your LOI, even if you have to have a price term in there, you have to specify all the different levels of diligence and things that you might have to do, because so long as you can put enough in there to argue to SBA successfully and show them that it was sufficiently unlikely or not likely to occur that this deal would go through without certain hurdles being met, and simple saying, well, I still have to look at the financials, I still have to do that stuff, that's not sufficient. So you need to make sure that you put as many conditions in there as possible. The more the merrier. It's a sliding scale to be able to argue that the letter of intent wasn't sufficiently definite to give rise to present effect. Because if it gives rise to present effect, they consider the transaction to have been consummated by matter of law for size purposes. So if you're selling your company and you have a letter of intent that is maybe crosses that line, and then you sign it, you bid on contracts, and let's say 6 months later you close the transaction, somebody could protest you and say, well, you had a signed letter of intent. Let's say somebody finds out about it. You had a signed letter of intent 2 months before, or a week before, 6 days before you bid that last contract, and the letter of intent was with Lockheed. So you are therefore a large business because it should have been given present effect. They should have treated the transaction as being consummated the date you signed the LOI, and so therefore the week or month or whatever after when you bid, you were already affiliated with Lockheed. And depending on the terms of the LOI, that might be true. You might be affiliated with Lockheed. So just even structuring the LOI, you need to be careful.
And just to finish the thought on letters of intent, you can have some provisions of it be binding. Typically, the letter of intent will have a confidentiality provision that says neither party can make an announcement about the deal, and they have to keep each other's information confidential. And buyers often, before they start incurring expenses for specialists and lawyers and accountants to do due diligence and their own time and effort, they're going to want some assurance from the seller, i.e. exclusivity, that they have 30, 60, 90 days to get their due diligence done. And in that period, the seller won't be shopping the company to other interested buyers. Those can be enforceable. So we talked about this a fair amount earlier, but when we talked about the seller preparing for the deal, this is just the mirror slide of that. When the buyer's doing their due diligence, they're going to want to review all the corporate records, registrations, financial statements, and tax filings, any bank and loan documentation, your commercial contracts, your government contracts, your employee benefit matters, all of these things. So, and principally, they're looking at those to confirm the purchase price and the valuation that they think the company's worth, and to make sure that they are not surprised with liabilities after closing.
And also, just from a government contracts perspective, one of the things that seems to come up fairly often, if you're buying a company that you think has some valuable IP, you need to make sure that that company still owns the IP. Because a lot of times, even though the government is never, ever, ever supposed to take ownership of intellectual property, even if they paid for the whole thing, probably everybody in the government will tell you the opposite, but it's false. The government is never supposed to take ownership. At most, they're supposed to take unlimited rights in whatever that IP is, which gives them everything they want. The only thing they get from ownership is basically stopping you from going into the commercial marketplace and selling it, which the government shouldn't care about. But the reason I said is because a lot of times the government is sneaking in clauses that are not FAR clauses. They're not any law or regulation for the reasons I just stated, where the government says anything you give us, deliver, we own. They're never supposed to say that, but they do it anyway. And then what can happen is the person believes they created it. They didn't read the contract carefully. They didn't even realize that clause was in there because it's not a FAR clause. And then they go forward and they want to sell, or you're looking to buy, and you realize that in one contract 15 years ago, the basis of this IP that they've created over the years, even if every single thing they built off of for the past 15 years has been their own, and they paid, came out of profits or G&A. It wasn't on a government contract. It was built completely at their own expense, and they have complete rights in that. The basis for that, the seed, the code that started that whole process, they don't own. That can be problematic, especially if the government then put it in other procurements or let other people build off of it. So it's something to really look for because it's sneaky and people don't think about it. Or even if they tried to restrict the rights 15 years ago, they didn't do it appropriately because they didn't use the legend in the FAR clause. They just put confidential proprietary property of XYZ company. That doesn't cut it. So these are the things that you really need to look for when you're doing due diligence in government contracts. Just a good example.
And that kind of brings us to the next slide more generally in terms of buyers' due diligence on government contracts. They're going to want to get as a buyer, you're going to want to get a schedule of which contracts that the target has or set aside contracts, particularly 8A contracts. What pending proposals the seller has outstanding. Are there recompetes in the offing? What kind of work is performed? Are there facility security clearances, import-export issues, and then what joint ventures the seller is involved in.
And one thing that is coming up more and more often too is off-ramps, the off-ramp provisions in contracts, because it used to not be the case. So if you could avoid triggering potentially certain recertifications or other issues, you were kind of scot-free. But some of the contracts now have off-ramp provisions that if you're acquired, no matter what, it doesn't say if you're acquired and you trigger recertification, or if you're acquired and you're not small anymore. It just says if you're acquired, then we're going to off-ramp you. Or if you're acquired and you're large, irrespective of any recertification requirement that you might be able to dodge through structuring of the deal, you might still be triggering an off-ramp. So just pay attention to that as well.
Now we're going to get into kind of government contracting considerations in M&A transactions a little bit more specifically.
Okay, so when we're talking about, there's a few questions that come up pretty often. When you're talking about small business set-aside contracts, or HubZone, or Woman-Owned, or 8A, or any of the SCVOSB, the whole gamut. So are they transferable? Yes. Generally speaking, the answer is yes. There might be a recertification requirement, there might be notice requirements, but generally you can transfer them. However, for 8A contracts, especially, and this isn't true for anything else, you do have to get a waiver. So you have to submit the waiver documentation to SBA prior to closing and consummating the transaction. If you do it after, or if you do it at the same time, it's very possible, we've had this happen in a transaction we brought into after the fact, where the SBA raised a lot of questions about the transaction and ultimately denied the waiver, sinking the entire deal, because they said that the waiver was submitted after you had already closed, even though it was basically the same time. SBA wants to see the waiver submitted beforehand. It can be the day before, but it's got to be beforehand. And also, you don't have to wait for SBA to grant the waiver to close the deal. What you're probably going to want to have is some sort of unwind provision or something, because if the waiver is not granted, the contract could be terminated for convenience unless it's returned back to the prior company. Recently, we also had a case where it was a legacy 8A contract that was held by a former 8A participant. So they still had the 8A contract ongoing. Those contracts are still subject to waiver, but we had SBA recently tell us in one case that we didn't have to get a waiver because it was a company that had graduated from the 8A program. That's actually wrong, but in that particular case, because we had an email, it was in writing from SBA, we said, look, if you're willing to take that potential risk, we do have it in writing, so you're protected most likely from a False Claim Act perspective. And they decided they don't want to submit the waiver and move forward. So just be aware that there is potentially confusion within SBA on this point, but really the waiver should have to be submitted, and but you don't have to wait for it to be approved. Otherwise, if you fail to submit the waiver, you risk a termination for convenience, because that's what the law says is supposed to occur. With regard to other programs, whether it's STVOSB, HUBZone, woman-owned, you don't need to get any sort of pre-approval, so it's not as critical. Let's see. We have a couple questions that would fit here. Please confirm a small business set-aside contract must be transferred to a similar business with the same set-aside. For instance, HUBZone has to be transferred to HUBZone. That's not really true. It's just if you transfer it to a company that's, say, a large business, then that company cannot recertify as small or as HUBZone, STVOSB, whatever it happens to be. That doesn't mean the contract is terminated. All that means is that the agency cannot continue to take the applicable credit for the dollars under that contract. So if you're at a point where the agency isn't in a position to terminate the contract because it's too important or they're already halfway done or whatever, that contract and the dollars on that contract could still be performed. It's just the agency can't use it to meet their goals. That's the way it's supposed to be. And that doesn't mean it's not at risk of being terminated potentially if the agency's goaling is paramount or if the contract is of such a large value that it would seriously impact the agency's goaling. It might be the case where they would transition it to another company. They'd T for C and transfer it over to another company, although obviously that raises other headaches about competition and going through that whole process. So it's usually unlikely that the agency would terminate. Another thing that was raised is, do you need to do novation of some contracts who you do work with in the government, and what CFR governs that? So when you're dealing with novations, it's part 42. So if you're looking at the FAR provisions for that are under 12 part 42. And I can get you that information after this in the exact clauses. Okay. So with regard to multiple award contracts, GWACs, and other things like that, you have to also, if you transfer them, all of the task orders are supposed to go with it. Again, as I mentioned before, there may be arguments where you could transfer just the task orders. I've never seen that happen. I've never seen it successful, and there's a lot of reasons why that should not be able to occur. So just be aware that it's something people think about doing. I've never seen it, and usually it has to all be transferred together. You also, if you transfer contracts, like I say, a multiple award contract where you have pending proposals, you have to recertify on the pending proposals. That's also true if you buy an entire company. Then what the rules say is that any pending proposals you have to recertify to the government as to whether or not you're still small. That's prior to award. So in those cases, if you're not small or if you don't fit the socioeconomic category that was relied upon and when you submitted the proposal, or if it was a specific set aside, it is likely that you would lose those contracts or task orders. So it's just something to be aware of. Another thing, when you're looking through and you're looking at, well, what are the types of contracts that are transferred? What are the potential issues? You need to be aware of import-export considerations. A lot of times, if you're talking about ITAR-related issues, it's things on the U.S. munitions list with the Department of State. And inside there, it's a laundry list of information. It's somewhat difficult without technical experts, which should be in the company, to determine whether or not the things are really applicable on that list. If they are on that list, you think they might be, you can actually go to DDTC, the Director of Defense Trade Controls, and seek a advisory opinion as to whether or not they are, and that should give you some coverage. It takes time, but depending on the size of the deal and the importance of the ITAR considerations, it could be very important. Unfortunately, SBA and other agencies don't give advisory opinions, or a lot of other agencies don't give advisory opinions. So you can't do something similar and say, well, am I affiliated? Let me get an opinion from SBA. They're not going to do that. But when you're talking about ITAR, the State Department does do that. EAR is if something's not on ITAR, then it could potentially be covered by the Export Administration Regulations, or EAR, and that's done by the Department of Commerce. So first you look at whatever you're doing and say, well, is it on the U.S. munitions list? If the answer is no, well, then let's look through the Export Administration Regulations, see if it could possibly be on that. If the answer is still no, then you go to EAR 99, which is like a catch-all. If you're confident that it's not under those things, then you're okay to transfer and have foreign persons have access to it. The main things where this comes up is if something is covered by, let's say, ITAR, and let's say you're in the midst of potentially selling the company, and you want to show off this IP, for instance, and let's say it's covered by ITAR. The buyer is owned by someone who's a foreign national, not a U.S. citizen, even if they have a green card. That foreign national comes on your premises. You're like, look at this IP, look at this software. It's really amazing. You didn't export it out of the country, but by showing it to that person, you just exported it. It's what they call a deemed export. And so that can get you into trouble. Similarly, if you give employees, let's say you hire H-1Bs, something like that, to come in and you give them access to that equipment or materials, you could also have deemed to export it. So just something to think about as you're going through the process. Another thing that comes up quite often is OCI issues. A lot of times I've seen buyers try to have the seller rep and warrant to the fact that when the buyer buys it, there's going to be no OCIs. That's a little ridiculous, because from the OCI perspective, how is the seller supposed to know what the buyer has or doesn't have without doing reverse due diligence and looking at all the contracts that the buyer might have? That doesn't happen. And so if you see clauses like that and you're a seller, push back on it. Where at the same time, when you're doing these OCI issues and you're the buyer, you do need to pay particular attention to not just all the contracts you're looking at. You need to pay attention to what you have. And the bigger the company and the more contracts, the more diversified you are, the more risk you might have that you're going to walk into an OCI by doing an acquisition. So pay attention to those things. If you need to be proactive and put some sort of OCI mitigation plan in place, do that ahead of time. And if you might need to even reach out to the contracting officers on your legacy work, the work that you still have as a buyer, and let them know that you're going to do this acquisition, there's this potential OCI. Depending on the type of OCI, the mitigation plan may be more or less effective. So it's something to think about and talk through as you're going through that process to know the risk level and to see if you can mitigate it. As far as the data rights issues, this is what I was talking about before, to just really pay attention to what you're buying to know whether or not you're actually getting the full value of what you think you're purchasing. Security clearances is also something that tends to come up pretty often. When you're talking about security clearances, to say an FCL, a facility clearance, when you have a facility clearance, you need to make sure the persons upon whom the security clearance is based are, if those people are staying with the company, that could potentially be fine. They can stay on as key personnel. But if new owners are coming in, the DSS rep might require those new owners to be listed and to go through the clearance process themselves. And if they're not eligible, you might have to firewall those people off. I've had that happen before, where individuals who had foreign ties through family members were purchasing companies. Doesn't mean that company necessarily loses its FCL. It just means that you might have to firewall off the owners, which might seem bizarre, but you have to firewall off the owners and people who control the company from control over the cleared activities. And so that's something that, again, as part of the acquisition process, you go to the DSS rep, you ask the DSS rep how they want to go through it, and then you walk through that process with them to ensure that after the acquisition takes place, you already have the firewalls in place and you already have the structure there, so you don't get in trouble on any cleared contracts. Similarly, if you do have classified contracts that are involved, you need to make sure that in your data room, you don't just shove everything into one data room. You have what they call a clean room that has very limited access to only people with the clearances required to access those contracts. And certain summaries are okay, but I'll give you fair warning that if it's extremely classified contract, we'll call it, if it's with one of the three-letter agencies, you need to make sure that even summaries and other documentation is sort of cleared through the respective offices to make sure you're not giving away too much, because on some of the highly classified contracts, they can get rather antsy about that. I think we can go through this kind of briefly, but when you're talking about non-U.S. buyers, you need to worry about foci, and CFIUS. So the foreign ownership and control is foci issues where when you're looking at that, you might need to put up firewalls and take similar actions, just like what we talked about for clearances. Right.
You might have to put in independent directors on the business being acquired, so that a non and the independent directors are generally U.S. persons and not affiliated with either the seller or the buyer, to satisfy the government that you've taken care of, if you will, the issue that was causing the foreign ownership control influence. Just briefly mentioned CFIUS. You need to kind of involve your lawyers early in a transaction where there's going to be a foreign buyer, to make sure that to determine whether or not you need the seller company. If it's an industry that's sensitive to national security, you may have to make a voluntary filing with pursuant to CFIUS, and which is excuse me, passed under Exxon Florio, and it's a voluntary process, but that read air quotes in your head when you hear voluntary, because if you don't follow it, it can jeopardize the whole transaction.
Yeah, and the larger the transaction or the more complex it is, the more security implications there are, the worse it can be. Because if they come in after the fact and you failed to voluntarily disclose, they can scuttle the deal, which I think happened recently with that port. I think there was a port that was going to be purchased by the Saudi company. That's the kind of thing that sort of large scale thing has more risk than smaller transactions, but something to be aware of.
Other government contract considerations, what term is left on the contract itself, whether there's any recompetes coming up. You need to think about the sellers, how effective their compliance regime has been, and how effective an internal control arrangement they have set up to manage compliance with any audit requirements and reporting requirements under the contract. You need to assess kind of what employees are critical to performance under of the asset, the contract you're acquiring or the business you're acquiring. I don't know if we want to talk about the service contract.
Yeah, and also with the employee issues, if you need to keep critical people, it's good to know that ahead of time, get the list of the key people you need, because you might have to provide certain key employee or executive incentive plans sort of tangentially while you're getting all the purchase documents together. And then with regard to Service Contract Act issues, that's just something that seems to come up also quite often, because, again, the government a lot of times fails to include the appropriate wage determinations in the contracts, or they fail to include the Service Contract Act provision, the FAR clause, in the contracts, which under the law means that the SCA does not apply to that contract. However, the DOL can come in and do an audit and say, well, it should have, and we're going to apply it now, and we're going to apply it retroactively. Well, in that case, then you're forced to go to the contracting officer and try to get a mod to mod the contract to appropriately include the wage termination and the cost that goes along with it. You could get stuck between DOL saying, we don't care if the contract's modded, you owe the back wages to your employees, and the CO saying, we don't think that that should have applied. And then you're stuck between the CO and DOL, and the CO and DOL aren't going to argue with each other. They're just going to each say no to you, and you're stuck dealing with it. We had a situation like that where we actually had to get a senator involved, and it wasn't until the senator got involved and there was potential legal actions and claims being filed and all kinds of things that the CO finally agreed, fine, we'll mod it. And DOL the whole time was demanding, where's the money? We're going to come after you. It was kind of messy. So just be aware as you're doing your diligence to think through those things as well. Another thing when you're dealing with pending proposals, generally speaking, they're transferable if you put them in the contract, but there could be a circumstance if the government thinks that all you're doing is basically selling a proposal and you don't have the adequate, you're not really a successor in interest because the buyer hasn't purchased the requisite assets, employees, skills, expertise as shown in the proposal. It's possible that even if you bought it, that the government could still reject the proposal, or after award, someone could protest you, and you could be susceptible to a protest because you didn't actually acquire everything necessary to do the work. Also, like I mentioned, you do have to recertify. If you acquired a company and there's pending proposals, you have to recertify as whether or not you're large or under the appropriate socioeconomic categories. With subcontracts, make sure that there's nothing in there that's going to require pre-approval, because if you didn't get pre-approval, then that could give the prime contractor grounds to terminate the subcontract, and then you lose that revenue stream, especially if it's important. With regard to teaming agreements, they're generally not enforceable, so you should know that going in. You might be able to enforce exclusivity provisions, or somebody might be able to enforce it against you. And there's sort of an open question in certain jurisdictions like Virginia as to whether or not somebody could kick you off of the teaming agreement, yet still try to enforce the exclusivity provision as being binding. Even though they're not going forward with the teaming agreement. That's probably unlikely, but it's just something to be aware of. With regard to joint ventures, if you buy a member of a joint venture, that's going to require the joint venture itself to recertify on its contracts. So be aware of that also. So if you're buying say it's a mentor, if you're acquiring the mentor in a mentor-protege JV, who cares? Because even if the mentor is large, it doesn't trigger any impact of the joint venture. But if you're buying the leading venture, who is say 8A or woman-owned or hubs-owned or even just a vanilla small business, if that triggers that company to be large, the JV is going to have to recertify as large itself, and that could cause problems. Similarly with mentor-protege agreements, the same, that you don't have to recertify under a mentor-protege agreement, but if the protege is no longer small because you bought them, then any sort of JVs or later bids, just because there's a mentor protege in place, the protege's size matters at the time they certify for the contract, not the mentor protege itself.
Just a brief overview of what your definitive, the key elements of your definitive purchase agreement will look like. Of course, it'll have the elements of the purchase price in it. Be it cash, be it notes. Often in government contracting space, we see earnouts utilized. There'll be some amount of cash purchase price, but a large percentage of the consideration is typically tied up in an earnout, which can be measured on revenue or on EBITDA, and it's usually over a period of years. Those are somewhat those are tricky to draft properly to protect the interests of the client. So you really need to kind of focus on what can seem to be legalese as a business person when you're working with your lawyer to craft an earnout provision that protects you appropriately. And then a huge portion of the purchase agreement is going to be representations and warranties. I mentioned earlier that buyers are interested in protecting themselves from liabilities. one of the principal methods they do that after they've done their due diligence and still want to go forward with the deal is the reps and warranties. They ask the seller to certify all kinds of things to them, or represent to them, I should say, not certify, that are true. We've looked through your things. We don't think there's any liabilities, but we want you to affirmatively tell us, seller, that you have no liabilities that you haven't disclosed to us. And then tied the teeth to tie into that. It's not simply a breach of contract claim you would have if one of the reps the seller gave wasn't true. There's an elaborate indemnification arrangement where the buyer and the seller negotiate kind of how much of the seller's purchase price is at risk if inadvertently they breached one of their representations and warranties that they made to the buyer. You can get quite elaborate with that on smaller deals. That's not frequently as elaborate, but it can get fairly complex and customized. And then finally, the other kind of main provision of the purchase agreement will be what happens after the closing. Typically, there's a working capital provision in these agreements that the seller's agreeing to deliver a certain level of working capital along with the business at closing, and the seller estimates that at closing, and then the buyer gets to investigate it after closing and see if the buyer agrees with what the seller said. If there's a difference between what the buyer found and what the seller said was delivered, then there'll be an adjustment to the purchase price up or down. And there's also covenants if you've done an asset acquisition and you're waiting for the pendency of a novation to be approved by the government, there's usually covenants about how the novation process and cooperation with each other in seeking to make that happen, and potentially an unwind if unfortunately novation doesn't go through.
Yeah, and I think we're about out of time, but really quickly with regard to some of the novation issues, I know there's a lot of questions on that, and we'll definitely get to the questions after this. We'll follow up with everybody who has asked questions that we didn't get to. But with regard to novations, it's one of those things that I think we should say that if you're trying to novate, like if you buy all the assets of a company, or if there's an IDIQ that has a lot of work on task orders, you're much more likely to get that through, especially recently, like literally in the past few weeks. I've seen a few cases where GSA is really being sticklers, and they have been in the past, but not to this extent, where they're really questioning every single little asset that's listed in the asset purchase agreement, because they're questioning whether or not companies are trying to buy and sell sort of what I would call naked contracts, where there's no like assets being used. It's just the contract itself, and that's technically prohibited under the law. And so where in the past you could say, well, there's other assets, right, that are being acquired. There's like IP and other things. Well, GSA has been coming back and wanting detail on the various assets. And so it's just something, especially with GSA, to be aware of, given the number of IDIQs that GSA puts out there, that novations are seemingly becoming more difficult in very, very recently. And I think it has to do with a lot of the, at least with GSA, some of the lawyers that we used to work with on a regular basis have retired, and the new people coming in are much more difficult to deal with. So just raising that issue. And I think we're out of time, so thank you everybody for attending. And like I said, we will definitely take a look at some of the questions, get back to everyone, and of course, we're always happy to take things offline as well if you want to email and talk to us then. So thank you very much, and I hope everyone has a great rest of the day.